Offer and acceptance. Meaning of offer or proposal. Section 2, Clause A. When one person signifies to another his willingness to do or abstain from doing something with a view to obtain the assent from another to such act or abstinence, he is said to make a proposal. Types of offers. First, on the basis of formation, there are two types of offer. First, express offer. When an offer is made in words written or spoken is known as express offer. An offer can be made by words, whether written or oral. The written offer can be made by letters, telegrams, fax, email, advertisement, etc. The oral offer can be made either in person or over the telephone. Second, implied offer. An offer made otherwise than words spoken or written is known as implied offer. Such an offer is inferred from the conduct of the parties or from circumstances of the case. Second, classification on the basis of offeree. On the basis of offeree, there are two types of offer. First, specific offer. When an offer is made to specific or particular or a certain person, it is known as specific offer. This offer can be accepted by the person to whom it is made. Second, general offer. An offer made to public at large is known as general offer. A general offer may be accepted by anyone by complying the terms of the offer. General offer creates liability for the offerer in favor of any person who happens to fulfill the conditions of the offer. Third, on the basis of formation, there are two types of offer. First, conditional offer. An offer expressing some conditions in it for the offeree to accept is known as conditional offer. Second, unconditional offer. An offer where offeree is not required to consider any conditions before accepting the same is known as unconditional offer. Fourth, on the basis of nature, there are three kinds of offer. First, cross offer, where two parties make identical offers to each other at the same time and in ignorance of each other's offer. The offer are known as cross offers. Cross offers are not treated as acceptance to each other and hence they are not capable of creating legal relationship arising out of the contract. Second, counter offer. When instead of accepting the offer, offeree accepts the same subject to certain conditions or qualifications, then he is said to make a counter offer. Third, standing offer. An offer of continuous nature is known as standing offer. It remains open for a long period of time. Essential requirements of a valid offer. An offer to be valid must satisfy the following requirements. First, offer must be capable of creating legal relation. Second, offer must be certain, definite, and not ambiguous. Third, offer must be communicated. Fourth, if offer is conditional, then the offer should contain all of them. Fifth, no terms or no conditions should be there, the non-compliance of which amounts to acceptance. Sixth, an offer must be different from invitation to offer. There is difference between tender and offer. A tender is an offer as it is in response to an invitation to offer. The person inviting the tender is giving invitation to offer. The persons filling up the tenders are giving offers. However, tender may be of two kinds. First, specific or definite, where the offer is to supply definite quantity of goods. Second, standing, where the offer is to supply goods periodically or in accordance with the requirements of the offeree. Spatial terms of the contract. Sometimes a contract is subjected to certain spatial terms and conditions, which are either printed on the back of the receipt or displayed in some other manner, evidencing the transaction. For example, dry cleaner's receipt, insurance policy, etc. Termination or lapse of offer. Section 6. An offer is made with a view to obtain assent thereto from another to whom the offer is made. Offer is a train of gunpowder and acceptance is a lighted matchstick for the purpose of creating legal relations. As soon as the offer is accepted, it becomes a promise and both the parties will be under legal relationship. But before it is accepted, offer may lapse due to the following reasons. First, the offer lapses after stipulated or reasonable time. Second, an offer lapses by death or insanity of the offerer or offeree before acceptance. Third, an offer terminates when rejected by the offeree. Fourth, an offer terminates when revoked by the offerer before acceptance. Fifth, an offer terminates by not being accepted in the mode prescribed, and if no mode is prescribed, then not being accepted in some usual or reasonable manner. Sixth, a conditional offer terminates when condition is not accepted by the offeree. Seventh, in case of counteroffer, original offer is lapsed. Acceptance. The Indian Contract Act 1872 defines acceptance as when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. Section 2, Clause B. In case of general offer, it can be accepted by the person who has knowledge of the offer. In case of specific offer, it can be accepted by specific person to whom the offer is made. An acceptance to be valid must fulfill certain conditions as follows. First, acceptance must be absolute and unqualified. Section 7. Second, acceptance must be communicated or signified to the offerer. Third, acceptance must be in the mode prescribed in the offer. Fourth, it should be in response to an offer. Fifth, acceptance must be given within time. Sixth, acceptance should be made before the lapse of offer. Communication of offer and acceptance. Communication of proposal or offer. Section 4. The communication of proposal is complete when it comes to the knowledge of the person to whom it is made. Communication of acceptance. Section 4. Communication of acceptance for the following. First, as against the proposer. Second, as against the acceptor. The communication of acceptance is completed, first, as against the proposer or offerer, when it is put in the course of transmission to him so as to be out of the power of the acceptor to stop it. Second, as against the acceptor, when it comes to the knowledge of the proposer to whom acceptance is made. Revocation of proposal and acceptance. Section 5. Section 5 provides that a proposal may be revoked at any time before the communication of acceptance is completed as against the proposer, but not afterwards. Also, an acceptance may be revoked at any time before the communication of acceptance is completed as against the acceptor, but not afterwards.